Hello there, my name is Stephanie Rojo, and I'm an associate attorney at Stone Law Offices in Las Vegas, Nevada, and we're here for your 5 at 5. What I'd like to discuss with you today is what does it mean to revoke a trust versus amend a trust versus restate a trust, and which options are the best option, which option is the best option for you to pursue. So first, let's just talk about the terms. Revoking your trust is completely eliminating your trust. It is saying that the trust existed, but you are terminating that trust. You are stopping it altogether. It has been defunded. There is nothing more to do with that trust moving forward. Amending your trust is surgically removing and replacing various provisions of your trust. Typically, this is done in a second document that's read side by side with your original trust. So you'll have your trust and your amendment, which says, for example, section 2.2 is removed entirely, or section 3.4 is replaced with the following language, or I am removing and replacing the trustees with these new trustees, or I'm adding an alternate trustee. So it is addressing a very specific point in your existing trust, and it is adjusting that point. It's either replacing it with new information, it's eliminating that provision, or it's modifying the provision slightly. And restating your trust, what that means is you do that when your trust is so outdated, it is so old and there are so many changes within the trust that you actually want to completely cut out the guts of your trust and replace the trust language with entirely new language. And rather than having 20 pages of amended material, you keep the original title of your trust and the original date of your trust, but everything from within is taken out and it's replaced with new language. So it's a complete overhaul of the trust document, but it doesn't actually remove the trust or eliminate the trust. It just improves it on a significant basis. So which route do you need to go, or do you even need to go these routes? So the best way to figure that out is to constantly have your fire drill reviews every 3 to 5 years, which is the industry standard. That's what we pursue with our clients. We invite them in every 3 to 5 years for that fire drill review so we can have a conversation about what's going on in their existing trust, what's happened in their lives, are there any changes that need to take place. During that conversation, we are identifying, is it just a handful of things that we're changing? Are we not changing anything? Or are there a lot of changes that need to take place? Was the tax language completely overhauled? And does that need to be replaced entirely, for example? So we as the estate planning attorneys are taking all this information in as we go through that fire drill review, and we are determining what the best step is to move forward. If it really is only 1 or 2 minor tweaks to the trust, then chances are an amendment is going to be the best way to go. If there are many, many changes that need to take place, then we are going to be recommending a restatement. Or even if the trust maybe came from another attorney's office or came from out of state and there are a lot of overhaul items that need to take place, once again, we are going to very likely recommend a restatement. But keep in mind, we are evaluating this on a case-by-case basis with the client that's sitting across the table from us or on the phone with us or on the Zoom call. So we aren't just going into that meeting with preconceived notions on what we're going to recommend to the clients. We actually are taking that input, we're processing it, and then we are responding to the clients with the best mode of action to move forward. Now, revoking a trust, that's something that we take very seriously, and we want to make sure we understand all of the ins and outs on why you want that trust to be revoked. We want to make sure that you have an alternate estate plan in place before we will actually move forward with a revocation. And once again, we will take that on a case-by-case basis, but I will tell you now that it is very rare to revoke a previous trust. Unless someone has completely redone their trust, they wanted to change the name entirely and they've moved all their assets into the new trust, in that situation, we would be revoking the older trust. But if a person had a trust their whole life and then maybe they have spent down most of the assets that they had owned in the trust, even then we may still recommend that that trust remain open, because upon their passing, if that individual passed away in some kind of odd accident where it was a wrongful death case and the estate could pursue a wrongful death claim, or there's possibly monies that could be awarded, we'd want those funds to be pushed into the trust and be distributed according to the trust terms. So once again, we would take that information in stride and we would work with the client to figure out what the best option is. So whether it is keeping your existing trust, amending it, restating it, or revoking it, the estate planning attorneys at Stone Law Offices are ready and on standby to discuss your options with you. If you haven't met with your estate planning attorney for some time, this might be the opportunity for you to consider a change. You are welcome to call our office. Our phone number is 702-998-0444. I look forward to hearing from you and reviewing your estate plan.